The Honorable Supreme Court of the State of North Dakota is now in session.
Good afternoon. Please be seated. We are here at the time set for oral argument in file number 2025-0461 in the matter of the petition for leave of appeal of Lindsay Dansdill. Arguing this afternoon for the appellant is Michael Simpson and for the appellee, Kara Erickson. Sitting this afternoon are Justices Jared Tufte, John Jensen, Douglas Barr, and Mark Fries, and I am Lisa Fair McEvers. Mr. Simpson, when you're ready, you may approach the podium and proceed.
Thank you, Your Honor. May it please the Court. As you mentioned, my name is Greg Simpson. I go by my middle name, Greg Simpson. I represent the appellant, Lindsay Dansdill, in this case. Your Honor, Lindsay Dansdill petitioned this Court to initially to appeal an admonition issued by the Inquiry Committee West that was affirmed by the Disciplinary Board of the Supreme Court. The admonition was based on the committee's conclusion on clear and convincing evidence that Ms. Dansdill had violated North Dakota Rule of Professional Conduct 5.5, which deals with unauthorized practice of law. And she had done so, quote, by appearing in North Dakota courts without being properly licensed, unquote. The committee expressly did not find that there was a violation of an attorney's duty of candor, which is Rule 3.3. I argued in my petition for leave to appeal that that was arbitrary and capricious because you cannot impose discipline cannot be imposed on an attorney for violation of the regulatory rules, the rules of admission, Rule 3 in particular. Because what the violation was, according to the Inquiry Committee West, was a failure to pay the fee and submit the Pro Hoc Vice application to the Board of Law Examiners as required by regulatory rules, the rules of admission. Nothing in the ethical rules, the rules of professional conduct that deal with that issue. So the court granted review, indicating, as I understand the standard of review, that there was at least some initial agreement that there was a procedural error, there was a due process error, and the standard of review at this second stage of the appeal is for this court to take a de novo review of the record under a clear and convincing standard of proof and determine for itself whether there was a violation of an ethical rule. And my position is that the record on appeal is pretty narrow. There was no formal proceeding below. All we know about what was decided is one piece of paper, which is the committee's decision. It's in the record. It's Appendix 107. And then there's the Board of Disciplinary, the board's affirmance of that, which is in the record at Appendix 110. And all it says, and this rules require that the Inquiry Committee state the reasons for the decision. And all we know about it is what they say in there. And what they say is that Ms. Dansdill violated Rule 5.5, and I'm quoting now, by appearing in North Dakota courts without being properly licensed. Then it goes on, it says it was determined that mitigating factors were present, and one of which was that she believed she was practicing properly without any notice to the contrary. So I think the record here is that there has been a finding in the lower administrative agencies that there was no violation of the duty of candor, which could be an ethical violation, but that was not what the lower agencies found. So the issue before you, this court, is whether it is permissible to impose discipline for a violation of a rule that requires payment of a fee to become admitted pro hoc vice.
Mr. Simpson, is the essence of the argument she had an order authorizing it, so whether she paid the fees, whether she complied with the things she said she had done, there was an order, so it wasn't unauthorized practice?
Exactly. And I think you cannot ding somebody, a lawyer, for practicing without authorization when she has an order of the court authorizing her to practice.
Well, wasn't there time before the order was issued that would meet the qualifications of the rule?
Yes, Your Honor, that was the argument. Let me provide the response. So the argument that counsel makes, that the board is making, is that there's a 45-day rule, which requires that within 45 days of your first appearance in a North Dakota court, you must apply for pro hoc vice admission. And there was a pleading filed, some sort of pleading, I'm not even sure if it's in the record, that had Ms. Dansdill's name on it, but it was signed by her local counsel. So that's the argument. But that rule is also found in the 45-day rule, is also found in the administrative rules, not in the ethical rules. My response to it is that wasn't really what was teed up in the lower agencies. That was not the issue. If you go back to what the original complaint was, had nothing to do with that. And if you look at the investigation, had nothing to do with that. And if you look at what the Inquiry Committee West considered in its deliberations at Appendix 28, had nothing to do with that. They were looking at whether failure to pay the fee was a violation of 5.5. So that wasn't the issue that was teed up. We didn't respond to it fully, but I think if I did respond to it fully now, I would say that if you look carefully at the rule as to when you're supposed to pay, when you're supposed to apply for pro hoc vice admission, it's not entirely clear what constitutes your first appearance. My client did not appear in court. She did not sign a pleading. A pleading was submitted, but then...
Can't we assume that if local counsel included her name, she gave permission for her name to be on that pleading?
That's not in the record, but you can assume, I mean, that wasn't what was in the record. It's not currently there. It wasn't investigated. I didn't respond to that issue. I think it's a fair assumption, candidly, that that's probably the case.
But the practice of law is more than appearing in court. There were depositions, there was discovery, there was all sorts of things that were going on before court appearances, correct?
I don't think that's the case. Again, that is not in the record. But what the explanation that is in the record, somewhere in Ms. Erickson's report, is that there was settlement negotiations going on, and that's why it took, and at some point, my client, the settlement negotiations broke down. It was necessary to move forward with the litigation. That's when you see an email from local counsel, the North Dakota counsel, to my client saying, okay, you need to file your pro hoc vice admission immediately. And in that same span of time, my client was moving from one firm to another, so that there was another reason why there was a lapse. But then she does, when she gets the email from her local counsel, she immediately files the motion for pro hoc vice admission with the affidavit, which states incorrectly that she has paid the fee. And
that misrepresentation is important, right? I mean, I can logically understand how the disciplinary authorities concluded she didn't knowingly misrepresent something to the court. But compliance with the requirements to be properly licensed doesn't require a knowing violation.
That rule, the 45-day rule, is not found in the rules of professional conduct. The Rule 5.5 is the pro hoc vice admission that deals with the standard of conduct. And maybe it's worthwhile taking a step back and talking about what's the difference between standards of conduct, professional conduct, and rules of admission, regulatory rules. They do not rise to the level of the kind of conduct that this court and those who promulgated the rules of professional conduct felt bear on your ability to practice law. The purpose of rules of professional conduct are to protect the public. And the disciplinary system as a whole is to protect the public from predatory attorneys, incompetent attorneys, and so forth. The purpose of the rules of admission, completely different.
Who promulgates those rules of admission?
I was hoping you wouldn't ask me that.
Because here's the problem that I'm having, counsel. You seem to suggest that based on a district court order, your client is free to practice even though for 3 years she's not paid her fees, she's not complied with the rules of admission promulgated by this court. And the district court under our statutory and constitutional scheme has no authority to supersede what this court requires. Section 271102 of the Century Code says the power to admit persons to practice as attorneys and counsels at law is vested with the Supreme Court, not the district court. How do you reconcile your argument with that and our Constitution, Article 6, Section 3, which vests that authority in this court?
Yeah, and this court totally has the authority to impose rules, regulatory rules that require payments of fees as a condition of being admitted pro acquiesce. But in this case, because of the error that we've discussed ad nauseum, my client didn't pay the fee, didn't comply with the rule, didn't know she hadn't complied with the rule. She didn't comply with your regulatory rules, rule of admission. But again, those are rules that pertain to admission. The district court, Judge Susan Bailey, district court judge, signed an order. It's
Judge Van de Streek, actually.
Sorry?
Go ahead, Justice Reese.
Well, here's where I'm having difficulty understanding your argument. Assume that my 19-year-old son misrepresents to the court that he's licensed and the court signs an order. He's never been to law school, he's never taken a bar exam, he's not admitted. Under your theory, he can continue to practice law until somebody catches that. Now, I understand there's a distinction between a knowing and an unintentional misrepresentation. Is that where you're asking us to draw the line because there was an unintentional misrepresentation here?
Yes, and so I did analyze that issue because that was how the issue was presented. This was initially a failure of candor to the court. That's how the complaint was presented. So that was what my initial response to the complaint focused on, 3.3. And my answer is what you just said. Knowingly is a defined term, and it was established. Not only is there not clear and convincing evidence that my client knowingly violated the rule, the contrary is true. There's clear and convincing evidence that she didn't know she violated the rule. But I had another answer to that, but I've lost it in the train of thought here.
But didn't the disciplinary authorities take that into consideration in formulating the disposition here?
Well,
she wasn't fined. Her pro hoc wasn't revoked. She wasn't, admonished publicly. They issued a private reprimand. They took all of those facts into consideration.
They only considered one violation. If you look at Ms. Erickson's report of what they considered, there was a motion. I'm looking for it right now. This is appendix page 28. The inquiry committee, on motion by Inquiry Committee West, a file was opened to investigate a potential violation of Rule 5.5. They never opened an investigation of Rule 3.3. That was what the initial complaint seemed to implicate, and that was what I focused on in my response to that. But that's not what the Inquiry Committee West focused on.
Mr. Simpson, you keep referring to the regulatory rules of admission. Although they were not ethical rules, don't they become relevant to the ethical rules, since the ethical rule is practice without a license? Don't you have to go to the regulatory rules to know if someone is practicing without a license? The
interconnection is in the affidavit that Ms. Dansdill submitted to the district court. That's where she had to, there are specific requirements in Rule 3, rule admission, that says you have to represent X, Y, and Z, and one of the things you have to represent is that you have paid the relevant fee. She thought she had. So all of this is happening on one day, right? This is the day that she applies. She submits her application on October 11, 2022. The same day she gets back notification that has been received. And so that her instructions from her local counsel were, when you get confirmation that the filing has been received, that's when you send in a set of the paperwork and her fee. That's when she emails to her office manager saying, hey, can you send the money in?
I understand all that. But my point is, you keep trying to distinguish the regulatory rules, the admission rules, from the ethical rules. They have to intermix in order to know whether she was in fact licensed to practice. And again, I think your ultimate answer is there was an order saying she could, so that's that.
Well, and now I remember this is what I was going to say to Justice Freeze, that there is it's Hornbook law that an order, no matter how bad it is a valid order that must be obeyed until it's reversed. And I don't think this order was a bad order. I think it was mistakenly issued on an honest mistake. And as did happen, Judge Bailey called my client on the carpet. And this is I think how this should be handled, and got a dressing down for filing an incorrect affidavit and being careless, which we all acknowledge happened. But was it an ethical violation? And to your point, violating a rule that does not itself appear in the rules of professional conduct cannot constitute independent of the candor issue.
Isn't the 5.5A exactly what the opposite of what you're arguing here? 5.5A says a lawyer shall not practice law in a jurisdiction where doing so would violate the regulation of the legal profession of that jurisdiction.
Well, if you read the comments to the rule, I mean it talks about what that means. That we're talking about the professional rules of conduct, not they're talking about professional standards that must be obeyed. And there are other, for example, in the, what are the other rules you have?
Well, there's a
that
reference to
specifically
rule,
say
there's a
that,
reference to Rule 3 right in B2. In 5.5B2, there's a reference to the admission to practice rule.
not familiar with that.
It says the lawyer acts with, it's an exception. It's saying they don't engage in the unauthorized practice of law when, and then it refers to, except for work for which pro hoc vice admission or registration under admission to practice is required.
Yes, and she applied for pro hoc vice admission and she got it. So
What about
now
all
I
the
understand.
time, what about all the time that is, I mean, that's the thing is, there was practice before the order was signed by the judge.
Yeah, we know very little about that because nothing really happened. We know that there was something filed that had my client's name on it. We don't know that there was any appearance in court. We don't know that there was any litigation activity. But that was, again, not the focus of the Inquiry Committee West. And I have to, there seems to be an underlying current that if the court finds a different violation than the one found by the Inquiry Committee West and affirmed by the board, then that's sufficient to substantiate the complaint. I don't think if you look at the court's precedents that that's ever happened. I think you look at Toth, you look at all the other cases where the court has overturned informal reprimand or admonitions that were handled by the informal procedure. It's an up or down vote. Either there was, either there was a basis for it or there wasn't. The court doesn't go in and try and find another rationale to backfill a violation to support the discipline. That's, as far as I can tell, that's never happened.
Mr. Simpson, assuming the court adopts your argument that a violation of the admission to practice rule doesn't constitute a professional misconduct, what about violation of a statute? Aren't attorneys required to follow statutes? And then the follow-up question that I have to that is, North Dakota law clearly criminalizes practicing law in North Dakota without a license under Section 271101 of the North Dakota Century Code. So even if we adopt your argument, are we to ignore that there's potentially a criminal violation here?
I'm back to my argument that I've made a couple times that she had a piece of paper signed by Judge Bailey that said she was authorized to practice in North Dakota. An order issued by a district court judge until it is overturned or reversed or vacated is valid and binding and must be obeyed. That's just Hornbook law. So, yeah, I mean.
Even if the statute requires payment of a fee and completion of all of the requirements in order.
I didn't know that the statute required that, does it? I mean, I'll look afterwards, but I wasn't aware of that. I thought the only requirement for payment of the fee came from Rule of Admission 3, Your Honor. So if there is another statute out there, I'm sorry I missed it. But that's, my understanding is Rule 3 doesn't have an enforcement mechanism except Rule 17 in the Rules of Admission. Rule 17 is the rule that says that this court can yank your admission, whether it's under pro hoc vice, whether it's any other form of admission to practice, if you lied. That's what Rule 17 says. I'm summarizing. But so that's the enforcement mechanism. It's right in there. There's nothing that says that it's enforced by the board or by the committee, Inquiry Committee West. It's something that this court can enforce. And frankly, the judge who issued the pro hoc vice motion can yank the admission, and she threatened to do that. She said, when she issued the order to show cause. So that's the appropriate remedy, and it doesn't need to rise to the level of an ethical inquiry. So I see my time is up, but I've saved 10 minutes for rebuttal.
Thank you, Mr. Simpson.
Thank you.
Ms. Erickson?
May it please the court, Chief Justice McEvers, Justices, Mr. Simpson. My name is Kara Erickson, and I am disciplinary counsel for the state of North Dakota. I am appearing today on behalf of the Disciplinary Board of the North Dakota Supreme Court. To answer some of the questions that arose during Mr. Simpson's argument, he stated that the 45-day rule was not part of the investigation and was not included as an issue. However, if you turn to the first full paragraph at the top of petitioner's appendix, page 41, you can find that argument. So that was part of the initial investigation and has been an issue throughout the proceedings. In looking at Rule 5.5, as Justice McEvers correctly pointed out, this is a situation where Ms. Dansdill was found to have violated Rule 5.5A, which states that a lawyer shall not practice law in a jurisdiction where doing so violates the regulation of the legal profession in that jurisdiction. The rules of professional conduct do not operate in a vacuum, but necessarily have interaction and are impacted by other rules and requirements within the legal profession. The short answer to the question posed by Ms. Dansdill is whether the disciplinary system is enforcing an administrative rule, and the answer is no. The board approved an admonition under 5.5 because Ms. Dansdill did not fall into one of the safe harbor exceptions under 5.5. Admissions Rule 3 provides guidance to lawyers seeking out those safe harbors and to the disciplinary committees in determining whether lawyers fell within the safe harbor exceptions to avoid discipline under the general rule of 5.5A. So from a technical standpoint, an exception to the general rule is not enforced. Rather, the general rule is what's being enforced. Now, every jurisdiction in the country has some variation of Rule 5.5, and the vast majority do not have their admissions rules coupled together with their ethical rules or their pro hoc vice rules, for that matter. North Dakota is not unique in how those rules are separated. Specifically, looking to the provisions of Rule 5.5, it is necessary to consider lawyer licensing and admission requirements in conjunction with the provisions of Rule 5.5 regarding the unauthorized practice of law. The regulations relating to pro hoc vice admission are directly cited within Rule 5.5. Specifically, admission to practice Rule 3 is cited 5 times within the black letter of Rule 5.5 and an additional 5 times within the comments to the rule. By enforcing Rule 5.5, in consideration of the admissions to practice rules, it is giving meaning to the citations identified within the language of 5.5 and its comments. without considering the admissions to practice rules, enforcement of subsection A would significantly change, because that is where several of the safe harbors fall under Rule 5.5B and C, which directly cite the admission to practice Rule 3 language.
Ms. Erickson, I don't remember your response to the argument that there was a court order. I know you're saying she didn't properly comply to get the court order, but there was a court order.
There was. And if you look to Rule 3, which informs the decision, the language within Rule 3 of the Rules of Admission states that in order to be permitted to appear in a trial court of this state, the lawyer must first designate associate counsel licensed in this state, file a motion requesting permission to appear and an affidavit with the trial court, file a copy of the motion and affidavit with the State Board of Law Examiners at the same time, remit to the required fee to the State Board of Law Examiners, and obtain permission from the court.
Right, but
So that's
the
a
court
fifth-
issued the order despite those 5 not being done, maybe incorrectly, maybe assuming what was said in the petition was accurate. But what about the case law that the order is valid until someone overturns it or withdraws it?
Within the ethical context, she did not meet the requirements. We're not in the district court. So while the district court may have found something as far as what happened or what didn't happen, that doesn't mean that the conduct was ethical. And so while there was an order that does not alleviate her obligations to follow the remaining steps.
And correct me if I'm misunderstanding, in other words, the district court allowed Ms. Dansdill to appear in that proceeding to its end, but that doesn't change the underlying facts that she didn't meet the elements of that rule.
Correct.
So the case law about until the order is overturned, is that specific to that case?
Specific to the district court
The
case.
district court case?
Correct. So there may be, for example, something similar that maybe could occur in a district court proceeding. If there's a motion for somebody to recuse themselves, for example, with an attorney or another party isn't able to represent somebody, the district court may issue an order now saying that that attorney may stay or not stay. When we get into the proceedings in front of the ethical committees, we may find out that there were some additional facts or different things that were going on, which maybe that attorney should not have stayed.
So hypothetically, an attorney from another state appearing, I know some of the things that they have to include is how many times they've appeared and all those kinds. So they could apply for admission through Pro Hoc Vici in 2 different cases before 2 different judges, and one might allow them to appear and one might not? Or if you're allowed in Pro Hoc Vici in one, are you allowed Pro Hoc Vici in all?
I believe you have to obtain permission from each court.
From each judge in each case?
Right, and theoretically, that's part of the reason why the State Board of Law Examiners would be alerted pursuant to that 4th provision. With the filing of the paperwork, hopefully they would catch that, and that there may be some information or guidance that could be provided by them to the lawyer seeking permission to appear in front of the district court.
Does the board issue a license to a lawyer admitted pro hoc?
They do not.
So 271101 has that as the second requirement, that the lawyer has to have secured an annual license from the board. Pro hoc lawyers can't comply with that because they don't get a license? I mean, I realize we're talking about rules here, not that statute, but my colleague brought it up, so.
My understanding from the Board of Law Examiners is that there is not a physical card like you and I get from paying our annual fees. So I don't think
They're given a number, aren't they not?
they are.
Yes.
And that statute starts with the preface, except as otherwise provided by law or rule adopted by the Supreme Court. So that also would incorporate admission to practice rules and Pro Hoc Vici rules, presumably?
I would presume so, yes. Although the criminal portion of it that you inquired about earlier would be prosecuted by the state's attorney's office and not by my office. In looking at the safe harbor provisions, Ms. Dansdill is attempting to insert herself into Safe Harbor 5.5B3, which specifically states that for matters for which pro hoc vice is available under admission to practice Rule 3, the lawyer is authorized to represent a client. However, when you look at that language, by her own admission, she did not fulfill steps 3 and 4. It does not read that you complete the first 4 steps and the district court will grant your pro hoc vice application and absolve you of completing the other steps. Again, we must give the rule language meaning, specifically the word "and" with respect to the requirement to obtain the district court's permission. If the requirements for the safe harbor are not met due to a failure to comply with Admission Rule 3, the legal services are provided in the state, then a violation of Rule 5.5A is present. Dansdill argues also that she falls within Safe Harbor 5.5B because she had that order granting her admission. Again, in looking at both the Safe Harbor and the associated comment, Comment 5, they both specifically reference Admission Rule 3. It was a necessary and required step to obtain the order, but it does not absolve her with the ability, or the requirement, rather, to complete the other provisions. The obligation to ensure that those steps are completed rests with the lawyer, and that there is not a potential ethical consequence under Rule 5.5A. The second violation of Rule 5.5A occurred because Dansdill was designated as counsel in the pleadings several months before her motion for pro hoc vice admission was made. Again, 5.5B3 did not apply in this instance. The safe harbor did not create an exception. Once filings had been made in the district court, Ms. Dansdill was no longer preparing for the matter. The action was commenced with the service of a summons. She argues she should not be held accountable for her name being put on a document that she did not sign. However, again, in looking to Admission Rule 3 for guidance on whether she fell into the safe harbor provision, it states under 3.3A, or excuse me, Admission Rule 3A, pro hoc vice admission is required for all non-resident lawyers admitted and licensed to practice in another state, but not licensed in North Dakota, who engage in the practice of law in this state by appearing either in person, by signing pleadings, or by being designated as counsel in actions filed in state courts. Admission to practice Rule 3 goes on to state that the motion requesting permission must be filed no later than 45 days after the service of the pleading, motion, or other paper. Again, an exception to enforcement is created by Admission Rule 3. However, again, Ms. Dansdill failed to fall into the exception. By reading, or by following Admission to Rule 3, or Admission to Practice Rule 3, as directly referenced in 5.5B3, Ms. Dansdill did not fall into the safe harbor created for pro hoc vice admission. Accordingly, she is subject to the discipline for violation of 5.5A. In both instances, Ms. Dansdill asserts that she falls into the safe harbor of 5.5B3. However, she is reading the language of the ethical rule without adding in the context provided by the direct citation to Admission Rule 3. The citation language is there for a reason, and it cannot be skipped over. Rather, it must be given meaning. In imposing discipline, the Inquiry Committee West found that Dansdill believed she was acting properly without notice to the contrary. That language indicates that the Inquiry Committee West found that Ms. Dansdill was acting negligently, but that she still engaged in the practice of law by failing to fall into one of the safe harbors. Accordingly, it found that a violation of Rule 5.5 was present. Now, under 5.5, there is no requisite mental state for the imposition of a violation, unlike Rule 3, as pointed out by Mr. Simpson. Rather, the mental state of the lawyer is looked at when reviewing the potential sanctions considered. Standard 7.0 of the North Dakota Standards for Imposing Lawyer Sanctions governs unauthorized practice of law. Both Standard 7.3 and 7.4 suggest the imposition of discipline in cases where the conduct was negligent. Standard 7.4 suggests an admonition when the lawyer engages in an isolated incident of negligence in determining whether the lawyer's conduct violates a duty to the profession. Now, in this situation, part of my responsibility is also to ensure that discipline across the board is consistent. If a lawyer in North Dakota were to do this, they would also receive an admonition for a failure to comply with the licensing requirements. So similarly, Ms. Dansdill, her conduct merited at a minimum an admonition. Now, admonitions are typically private discipline that do not impact the lawyer's ability to practice law. Whether the admonition would even need to be reported to other states would depend on the requirements within those states, but they are not reported out as a matter of our discipline. In looking at the imposition of the discipline, unlike in Toth, there's not an inconsistency with the findings and the discipline imposed. Here, the standards were used as guidance for the disposition, which can be seen in the disposition language of Inquiry Committee West, which specifically makes findings regarding mitigation and the lawyer's mental state and injuries that occurred under Standards 9.3 as far as mitigating factors, and Standard 3.0 regarding the general mental state and impact to the client. The disciplinary board of the court respectfully requests the court approve or uphold its approval of the admonition imposed by Inquiry Committee West because clear and convincing evidence was present that Dansdill violated Rule 5.5 of the Rules of Professional Conduct and that its disposition was not arbitrary, capricious, or unreasonable. Thank you.
Thank you, Mr. Erickson. You have 10 minutes for rebuttal, Mr. Simpson.
Your Honor. May it please the court again. The court should not accept the invitation to make the violation by an attorney of the rules of admission without an accompanying violation of the rule of candor an independent violation. There should be, that's the position that I've advocated here, that the rules of admission come into play in applying for admission, and you have to represent to the court that you have paid the fee and all of that. But the rules of admission should not be independently the basis for discipline. And this case illustrates that, because here we have pretty strong evidence that there was no intention. There's no intentionality and no knowledge of the violation. But there is, because we're dealing with rules of admission, it's strict liability, because they're not intended to form the basis for a standard of conduct. They don't have like intent and knowledge built into them, because they were never designed to be the basis for discipline. The rules of professional conduct, on the other hand, do have those elements of intent, knowledge, and so forth built into them. They even have definitions of those things. And I think it's an invitation to and there's no precedent for it. There's no prior case issued by this court in which discipline was premised on the violation of something other than a rule of professional conduct. And if you look at
Is that the nature of the rules, or by nature of the fact that these most often result in a private admonition and this court never sees them?
Well, I don't know. I guess yeah. But it would be improper if there was discipline. In my view, it would be improper if there was discipline being imposed based on violations of things other than disciplinary rules. Of course, there's no way to know if it's happening and not ever resulting in a published opinion. But certainly haven't heard of it, and I've been around for a while, so. A couple arguments that I heard that I want to respond to. Chief Justice Farron-McKeevers, you mentioned that 5.5 incorporates Rule 3 by reference, but it's important to see how it incorporates it. It says in paragraph 5.5A that a lawyer shall not practice law in a jurisdiction where doing so violates the regulation of the legal profession. But then paragraph B says basically, but you don't violate the rules, the regulations of a profession if, and then 1, 2, and 3, and one of them is the one we're talking about, the pro hoc vice admission. So you don't violate the rules, the regulations of the profession, according to the literal language of Rule 5.5, if you have been admitted pro hoc vice. And
Does it say that, if you've been admitted pro hoc vice, or is the reference, and I've closed my rule book, so now I can't look at it precisely, but, or in compliance with that rule?
It doesn't say in compliance with it. Here's what it says. 5.5B, a lawyer admitted to practice in another jurisdiction and not in this jurisdiction who performs legal services in this jurisdiction on a temporary basis does not engage in the unauthorized practice of law in this jurisdiction when, jumping down to paragraph 3, with respect to matters for which registration or pro hoc vice admission is available under admission to practice Rule 3, the lawyer is authorized to represent a client or is preparing for a matter in which the lawyer reasonably expects to be so authorized. So that's kind of my cure-all to both the argument on the rule on the 45 days. This is the ethical component, that it doesn't contain a 45-day requirement. It just says if you need to get admitted pro hoc vice if you reasonably expect, or no, you can appear in a case if you reasonably expect to be admitted pro hoc vice. Doesn't say you have to do it within 45 days of your first appearance. That rule is in the rules of admission. And so I think the way it's incorporated, Rule 3 is mentioned, but it doesn't say you have to be in literal compliance with Rule 3 in order to avail yourself of this safe harbor in 5.5B3. Now, of course, my client intended to be fully admitted and to have complied fully with Rule 3, and it was through inadvertence that she did not. And I think, the big question for the court is whether this kind of thing, a technical violation that doesn't implicate the values and concerns underlying the rules of professional conduct, deserves professional discipline. It's not found, the violation that she was found to have committed was not of anything found in the rules of professional conduct. It was only a violation of a rule, a regulatory rule that does not have any ethical connotations. I wanted to emphasize that there are significant collateral consequences to an attorney who has a national practice of having even a private form of discipline, an admonition, that it needs to be reported when she applies for admission in other states. And I don't know what maybe insurance purposes. There's a lot of collateral things that happen when you have a discipline on your record, and she hasn't previously had any discipline. A violation has to rise to a certain level to implicate that kind of collateral consequence. And really, this violation is not of something found in the rules of professional conduct. It's found in the rules for admission. And I've gone through my outline. I believe that I've responded to the questions that I could recall you asking, and if there's anything else, I will field it, but other than that, I'm going to sit down.
Hearing no further questions, thank you, Mr. Simpson, for your argument this afternoon, as well as you, Ms. Erickson. This case will be taken under advisement, as all cases are, and we are adjourned until 2 p.m. tomorrow afternoon.